Any mentioning not in the list?
Your Lordship. My lord.
Yes.
Madam.
Your Lordship, these three matters are out of the list. It will be disposed of because my clients have cleared the examination. So let it be listed, Your Lordship. Appropriate submission can be made and it can be disposed of.
To be mentioned or not?
Mentioned.
To be mentioned.
Amrish, I agree.
Your
You
Lordship.
notify your other side
Yes, I've just
tomorrow?
tomorrow.
Your Lordship. This is a repetition where I have assailed the second.
Which one?
It's not in the list, Your Lordship.
Yes.
I'm mentioning for listing of this matter and to be placed on 5th of August because, Your Lordship, my interim order will exhaust on the 7th. This is a application where I
Give it.
grateful.
5th August list করে দাও.
My lord, may I have my lord's kind leave to mention a matter not in the list, my lord.
Yes, Mr. Sarkar.
My lord, there are a bunch of writ petitions. Now, the writ petition, those bunch of writ petitions were allowed. The appeal has also been allowed.
Yes.
The appeal was dismissed. I mean, appeal was dismissed. Now, one matter, it was in the list, but at the final hearing, it was left out. I'll be praying, there'll be order in terms of the order passed by division bench.
Order, same order.
Any day, subject to my lord's convenience, if it can be fixed on Friday, subject to my convenience, my lord.
It is here.
Yes, my lord.
Give the slip. এটা কি এ করে দাও. It should be under the heading, what heading? For orders or to
All orders should be appropriate.
application এর আগে for orders করে দিও. Who's your other side?
Mr. Shatodru Chakraborty, my lord.
Yes, you are here. So Friday it will be listed. It belongs to that bunch, Mr. Sarkar says, so it can be disposed of.
I'm deeply obliged.
Friday. Very colorful background, colorful law books.
Thank you, my lord. Thank you.
Yes.
Any mentioning in the list?
Your Lordship, item number 66.
66.
Your Lordship, some preference because it is a matter relating to a child, Your Lordship. It's relating to the issuance of birth certificate. Birth certificate has not been issued and child is going to attain 1 year on 8th August.
Is for the union. Mr. Lal.
Mr. Lal will be there. So this issue has to be decided on, Your Lordship.
Tell us, I'll upgrade it when you want to do it.
Tomorrow, Your Lordship. Tomorrow.
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 শুনতে পাচ্ছ এটাকে top of এই category, top of এটা কি list? Hearing. Top of hearing list.
Your Lordship. Obliged.
Item number 1.
আর শোনো মনোজ, yes.
Item number 1.
My lord,
25 of 2021.
my lord, this I have mentioned, my lord. Here pleadings are completed. I pray it may be taken up for hearing. Some priority may be given, my lord.
Why priority,
My lord,
Mr.
already the issue was decided, similar issue was decided by the Honorable Supreme Court on 14th of January 2024, my lord.
So
My
it's
case is aptly covered with this.
amply covered?
My lord.
Very well. When, Sarah?
So any,
Day after tomorrow?
my lord, my lord.
Day after tomorrow, it will come under the heading, what heading?
Here-
Top of hearing list?
Yes,
Top of hearing, right?
Right.
Baba, top of hearing list.
it is raining, my lord. It's raining.
Item number 2. CRM SB 5 of 2019 with item number 3 CRM SB 10 of 2019.
Pass it over.
Item number 4. CO 26 of 24.
My lord, I am appearing for the petitioner.
Hearing for the copy number 1.
Yes,
Let a copy be given to me.
not served.
My lord, since it's a civil revision, my lord, so unless,
You serve
my lord, let it be taken up day after tomorrow then.
day after tomorrow.
I am filing Vakalatnama, my lord,
Yes.
on behalf of respondent number 1.
Item number 5, WPA 324 of 24.
I appeal for the respondent number 4 and 5. Today I file all Wakalat.
Pass it over. Petitioner is not here.
Item number 6, WPA 331 of 24.
My lord, I am appearing for the petitioner, my lord. Here I am seeking promotion from a retrospective date. Initially, I have approached the tribunal, my lord. Yes, initially I approached the tribunal, my lord. Pleadings were completed, but question of maintainability was taken. And ultimately, it was decided that it will not come within the ambit of the section 14 of the Tribunals Act. Therefore, I have withdrawn with liberty to approach this honorable court.
I would like to use my affidavit with regard to these.
My lord,
How long?
my lord, since
2
my client is, yes, I am
weeks.
grateful.
Issue, Stephen. The petitioner claims promotion with retrospective
My
effect.
lord,
The learned advocate for the respondents requests for time for her clients to file affidavit in opposition. Paragraph, let affidavit in opposition be filed within 2 weeks from date. After you write 2 weeks from date, then give the date. Okay, then give the date. Stop. Reply thereto, comma, if any,
What-
be filed within a week thereafter. Paragraph, list the matter after 3 weeks before the then available circuit bench under the heading hearing.
Item number 7, WPA 334 of 24.
This is the legislative authority, my lord.
They are disconnected. Or you have fresh application.
Fresh application.
Mr. Lal, what is there? These are all.
The question is,
Yes.
as per the supply code, he has to give the identification of the.
Sorry.
He has to give identification of the applicant.
Identification.
Right.
Whatever is necessary, he will
He
give.
has not given. This is in the petition, it is not there.
I'm not annexing the
It is not in the
Aadhaar card.
petition.
Sir, we will say whatever
We
documents
will
have to be
inspect- we will
submitted.
inspect and we will,
Yes, and you, with the time period, will specify, tell us when
Right.
will you. 2 weeks,
right.
2 weeks. But you find out what document you need to submit?
I'll provide my.
Yes. The petitioner seeks a direction on the respondent authorities to provide electricity to the dwelling house of the petitioner. Stop. Paragraph. Mr. Lal, learned advocate representing the respondents, says that the petitioner has not filed all necessary documents with this writ petition, and in particular, identification document.
Right.
Stop. Paragraph. It is well settled that electricity supply cannot be denied to any person who is in occupation of a property, whatever be his status whatever be his status in law. Paragraph, accordingly, this writ petition is disposed, I dispose of this writ petition by directing the respondents to provide electricity to the petitioner's dwelling house within a fortnight from the petitioner filing all requisite documents with the authorities
And complying the other conditions.
and complying with other formalities other formalities.
Item number 8. WPA 337 of 2024.
This is, my lord, premature. This is premature. The application is made on 10/7.
Tense,
Premature. It has,
what is it? Electricity?
Electricity matter, my lord.
it has to be, it is premature. It has to be decided within 30 years, 30 days. 30 days you have to.
Oh, they have been an application on 10 July.
10th July, my lord.
Then what is that? Withdraw it or what do I do?
Next circuit, my lord.
No, why next circuit? It's a
that
premature
will-
petition. They may well allow your prayer. How do you know?
And that will withdraw my.
Yes, this is a premature writ petition. Stop. Application for electric connection has been made on July 10,
10
comma-
July, 10 July.
2024. Stop. The respondents have 1 month
My lord.
to decide on such application, to take a decision on such application. Paragraph, in that view of the matter, comma, on the prayer made by learned advocate for the writ petitioner, comma, I permit him to withdraw this application. Stop. This will not prevent the writ petitioner from filing fresh writ petition if cause of action arises for the same.
Right.
Item number 9. WPA 341 of 2024.
Your Lordship, I am for the petitioner. Here, Your Lordship, the petitioner, who was the recorded tenant of a land measuring 2.02 hectares, submitted an application for diversion of land to commercial, 500 square meters of land. It was allowed. Then he again submitted 500 square meter, that was also allowed. So he felt that 1000 square meters of land is not sufficient. He wanted some more to be converted into, some part to be converted into commercial and some part into residential purpose. So he made 2 applications, one after another. One was in 2020 and another was in 2022. Both the applications are pending with the authorities, but in terms of our rules, Andaman and Nicobar Land Revenue and Land Reforms Rules 1968, it says that if the applications are not rejected by the subdivisional officer, then the subdivisional officer is required to receive the premium in respect of the land, which means for commercial purpose. If I want to use for commercial purpose, then premium has to be
Is there a time period for decision?
Time is not mentioned, but if only it has been said, if it is not rejected, then in that case,
Very good.
this is the method
So,
which is to be adopted,
Your applications have not been rejected.
not been rejected.
So
So
therefore,
my prayer is that
SDO should accept the premium.
premium.
Yes,
That is my prayer.
ma'am.
I have to take instructions since this is the first day it has come before my lords.
If the rules say so, you have to try to do
Yeah.
instruction day after tomorrow.
Yep.
Record an order. The petitioner says that it has applied to the competent authority for conversion of portions of its land for commercial use. Stop. The 2 applications are pending from 2020 and
2022.
2022, comma, respectively. Stop. Under the applicable rules, capital R, comma, the subdivisional officer, comma, before whom the applications are pending, comma, is obliged to accept premium from the petitioner, since the applications of the petitioner have not been rejected. Stop. Paragraph, learned advocate, rejected, stop. The petitioner prays for a direction on the subdivisional officer to accept such premium, stop. To accept the applicable premium, stop. Paragraph, learned advocate for the respondents seeks a little time to obtain instructions. Paragraph lists the matter once again on 1st August 1.
Your Lordship, not 2020, 2019, Your Lordship. One 2019 and one 2022.
2019 and 2022, all right?
Okay.
Item number 10. WPS 342 of 2024.
I am for the applicant. I saw the writ petition
I am
upon
for
the
the
respondents. Lordship, the issue is award passed by the labor court.
We will use our file or affidavit in opposition, my lord.
थोड़ा तो बता दो।
Yes, Mr. Khan.
Award passed by the labor court was affirmed up to the division bench and they went up to the Supreme Court. And Supreme Court, in lieu of the substitution of the award, remaining period was counted for giving compensation. But we filed an application for 17B before the Honorable Apex Court. Honorable Court, while disposing the application, said that because we are disposing the matter, if you have any surviving grievance, you approach before the respondent or appropriate authority. We filed an application under section 33C of the ID Act before the Labor Court, and Labor Court earlier occasion rejected claim that one-time settlement was done before the Supreme Court, so nothing remains to be decided. We challenge this order was set aside by this Honorable Court and remanded back to the Labor Court to decide the matter on merit. But again, on similar type order was passed. So we challenge this. Is required affidavits, Your Lordship.
Affidavits.
They are
We will
appearing
file
now.
affidavit. Today is the first day.
Come, Stephen. An order of the Industrial Tribunal oblique Labor Court, comma, A and N Islands, comma, Port Blair, passed in ID execution case number 01 of 2019, is under challenge in this writ petition. Stop. Paragraph, the respondent seeks time to file affidavit in opposition. Stop. Let such affidavit be filed.
4 weeks.
4 weeks.
Too long.
Within 3 weeks from date. Stop. Reply thereto, comma, if any be filed within a week thereafter. Mention the dates, huh? Paragraph, list this matter after 4 weeks before the then available circuit bench under the heading for hearing.
Oblige, my lord.
Item number 11.
Copy.
My lord, it may be taken up day after tomorrow, my lord.
Let a
It may be
copy
taken
be
up.
served.
I am sir.
Thank you.
Give a copy.
Yes. By mistake service name.
Item number 12. WPS 352 of 24. Item number 13. CRR 12 of 2024.
I appeal for the state.
Crossover.
Item number 14. CO 22 of 2024.
Lord, item number 14, I will appear for the respondent in this matter, my lord.
What the
Respondent,
opposite
it
party?
is civil revision. I have to file my wakalat now, my lord, because the client is under medical treatment mainland. He is coming on
You are the
Monday.
petitioner.
Let it fix on Tuesday, my lord, so that I get the brief as well as the wakalat nama. I will appear
On the prayer made on behalf of the opposite party,
appear with him.
comma, let this matter stand adjourned and be listed again on
Tuesday.
next Tuesday's date.
Oblige, my lord.
Item number 15. CRR 24 of 2024.
Allows my senior Mr. Govind appears for the respondent authorities in this matter, CBI authorities.
Petitioner is not here.
Not here.
Crossover.
Actually, my senior is not here. He wanted to fix this matter on Monday. As per your
We do that in the second call. Let us see if they come.
Yeah.
Get to that.
much of much.
Next.
My lord, 16 and 17 also same matters.
Crossover, both.
Item number 18.
In item number 18, I appeal for the state.
Crossover. Crossover, Ms. Dino.
Item number 19. WPA 261 of 2024.
My lord, my senior is for the petitioner. My He will be coming, he is gone to mainland. So let the matter fix on next Monday.
Monday,
Monday.
very well, Monday.
Item number 20.
Your Lordship, I have
Look
a
at
petitioner.
24.
This is actually the similar matter where appeals are pending before this honorable court fixed tomorrow. So let those appeal, if the appeal is disposed of in favor of the petitioner, the same order can be followed here also. So let it be fixed tomorrow. Possibly the appeal will be disposed of tomorrow.
Thursday.
Chances are.
Thursday.
Thursday.
Item number 21. This is 7 of 2019.
Item number 21 was not today.
Item number 22. CPN 31 of 2023.
Your Lordship, I appear for the alleged contempt. May a copy be served upon us, Your Lordship?
Fresh matter.
Yes, Your Lordship.
My lord, I am appearing for the petitioner.
First time.
No, my lord, it is not first time.
Filed to-
What, my lord, the judge passed the order is not there, my lord. So my
Your
lord may.
Lordship, on an earlier occasion, this matter was taken up, wherein on that date, the learned registry was directed to place this matter in the bench of the Honorable Justice Moushumi Bhattacharya. However, Your Lordship, till date, we have not received a copy, if at all a copy
It's
can
a
be.
contempt unless and until the court find that there is a contempt.
Yeah.
Yes.
Let us
If my
see.
learned friend asks, I can give the copy, but
Let us see the order one.
my lord. My lord may kindly come to page 12, my lord. An operative portion is at page 13, my lord.
Page?
Page 13, my lord. Operative portion, last paragraph. I will give you a copy, no issue.
They have not allowed you.
No, my lord. Thereafter, my lord, they carried this to the division bench, my lord. And division bench order, my lord, start at page 16. Relevant would be page number 17. Division bench dismissed their appeal, but time period was extended. If my lord comes to page 17, last paragraph, my lord. Last second paragraph, division bench says, accordingly, the order impugned deserved no interference.
Yeah.
And thereafter, the court says the appellant shall be free to proceed with the disciplinary proceeding and conclude the same
Yes.
within a period of 6 months from the date of communication.
Yes.
It is not till it is not disposed of.
Your
My
Lordship.
lord, there were altogether 3 writ petitioners.
Not disposed of, what is the violation you are complaining of? That they have not allowed you to have a defense assistant.
My lord, they allowed. Now, my lord, the court says, division bench says to dispose of the disciplinary proceeding within 6 months.
Then it should be a violation of the division bench order.
No, my lord, I filed it before the single bench, my lord, earlier. Actually, there were 3 matters.
Correct, Mr. Bindu Kumar. But then the learned single judge, did she give a time frame?
No,
She didn't give a time
no,
frame?
no.
So the time frame has been given by the division bench.
My lord, what happened, my lord? There were 3 set of writ petitions, my lord. My lord, I filed before the learned single judge. 2 passed by my lord Justice Moushumi Bhattacharya and 1 passed by my lord Justice Kaushik Chandra.
Yes.
When I taken out this contempt before the learned single judge, by that time, my lord, in one of the matter, there was a 3-judge bench in which I argued for the petitioner. Ultimately, the court held that the single bench is the appropriate authority, where if the order is merged with the order of the division bench, then the single bench is the appropriate authority. But whatever may be, my lord, when the matter was moved before the learned single judge, Justice Kaushik Chandra said, you move before the division bench. Thereafter, I filed a contempt before the division bench. But these 2 matters, one more matter, still pending before the learned single judge. This is the first time the matter is appearing, my lord. So I will place that order of the learned single judge, that is the Justice Kaushik Chandra, and it may be, I may be allowed to withdraw and
Do that.
yes,
Do that.
let it be tomorrow, my lord. I will prove
Your
like
Lordship, in that regard, if Your Lordship allows, if I can place that order
yes,
today.
yes. No, I appeared. I am saying
My learned senior friend has appeared.
so, my lord, thereafter it never appeared. This is the first time this matter is appearing.
Yes.
There is one more matter, my lord.
Your Lordship, the operative portion is in page 2, Your Lordship.
Yes.
My lord. No, my lord, only one thing, my lord. My lord, this matter, I have filed immediately contempt application was filed. This is the first time after more than a year the matter was. So whatever delay is there, my lord, because it is not on my, because of my fault, my lord. So that I can approach the division, my lord. Delay part, my lord, may kindly have it.
Yes, yes. So this will be disposed of.
Disposed of.
Huh.
And exactly it will be given to approach the.
Stephen. This contempt application has been taken out alleging violation.
Page 12, my lord. One more matter is there that tomorrow I will mention. Tomorrow I will mention. Actually, that file is not here. That's the difficulty. File is in Calcutta. This file was also in Calcutta, na?
Of an order dated August 25, 2022, passed by a learned judge of this court in WPA 132/2022. Paragraph. The operative portion of that order reads as follows. Set out bracketed portion from page 13. Paragraph. The order was carried in appeal.
Tomorrow
Stop.
I am going to mention the matter.
The division bench
Appear through virtual mode, same order will be also.
by an order dated November 21, 2022, passed in 22.
No, I will give my file or whatever I do. Otherwise, that will also linger
Disposed
for
of the appeal.
another 1 year and not.
Holding as follows,
I will
been
comment.
set out from page 17. Paragraph. Learned advocate for the petitioner says that in spite of clear direction of the division bench to conclude the disciplinary proceeding within 6 months from the date of communication of that order, the proceedings are still pending. Stop. This is the violation on the part of the alleged contemnor. One alleged contemnor? One. Stop. Paragraph. Learned advocate for the alleged contemnor says that this contempt application is not maintainable before a single judge. Stop. The violation alleged is of a direction of the division bench. Stop. Therefore, the petitioner should approach the division bench. Paragraph. An order dated August 8, 2023, passed by a coordinate bench in CPAN 27 of 2023 has been placed before me. Stop. The said order discusses the full bench decision, the special bench, or the special bench decision of this court in CPAN 26 of 2022, within bracket Shri Sailesh Kumar versus Messrs. Smitha are here. It is here, Mr. Stephen. Stop. The learned judge opined that if the violation alleged is of a direction of the division bench, then the petitioner should approach the division bench and not a single judge. Paragraph. In that view of the matter, now, paragraph, I am in respectful agreement with the aforesaid observation of the learned judge. Stop. Hence, comma, I allow the petitioner to withdraw this contempt application and approach the appropriate division bench if he is so advised. Stop. Paragraph. I only keep on record, put on record that the contempt application was filed before the single judge on June 14, 2023. Stop. However, it has come up for hearing for the first time before me today. Stop. Disposed of.
The delay part, last.
There is no question of condoning. How can I condone? You approach the division bench. I put on record that you filed it in.
One more matter is there, my lord. I will mention it.
Hence, just add this before disposing of, hence, comma, there does not appear to be any delay on the part of the petitioner.
Got it that all the allegations which has been leveled by the applicant hearing is denied on our.
Again,
Since no affidavit.
Since no affidavits have been called for, comma, the allegations made in the contempt petition shall be deemed to be denied by the alleged contemptor.
Great.
Then
More matter is there, my lord,
Yes.
but it has not
Similar.
been listed. Similar matter.
It will be listed.
Yes. The files are lying in Calcutta, my lord. I will mention it, my lord, because I have my skeleton file. Because of this, unless and until I able to withdraw, I cannot file it.
Correct.
And it was never listed, my lord. I have given several letters to the, only after my letters, this matter was listed.
Manoj, why don't you see that one? The file can in
Calcutta, my lord.
give the number.
Yes.
কোন রেজিস্ট্রেশন দরকার হলে আমার সঙ্গে কথা বলিয়ে দিও
Obliged.
give the number give the
Madam, I am giving the number.
Item number 23. CPL 47 of 23.
My lord, this matter, my lord, originally the order was passed by Justice Robindranath Shamanto. Then, my lord, it went to the division bench. Division bench has dismissed the appeal preferred by the administration. My lords, my instructions are, my lord, that either specially petition has been filed or it is in process, my lord. I let it come after 1 week. I'll
you are for the alleged contempt or
notice. I don't know if notice has been served, but my lords, I am for the alleged contempt.
they are not here. Pass over second call dismissal. My formula is simple. If first call nobody appears or seeks accommodation, nothing, then again second call nobody appears, dismissed. So pass over. Let's see.
Item number 24. CPN 32 of 2024.
Pass over.
My lord,
You're
in this
there.
matter, I am for the applicant, my lord. The order has been passed by Justice Tirthankar Ghosh, my lord.
Oh.
I pray that registry
Hey.
may be directed to place the file.
Yes. The order from a violation of which is alleged in this contempt application, comma, has been passed by another learned judge of this court, bracket right, Tirthankar Ghosh J. Paragraph, let this contempt application be placed before the appropriate bench.
Item number 25. CPN 33 of 2024.
Yeah, I'm for the petition, my lord. Here, my lord, Justice Devanshu Prasad sir has.
Order. Same order, this is just.
Item number 26.
Here, my-
on of 2024.
My lord, this is section 11, my lord, under the Arbitration and Conciliation Act, my lord, for extension of mandate. Now, my lords, I'm again for the respondent, but my lords, last time it got adjourned because, my lord, there's a decision of our court, of the Honorable Calcutta High Court of Justice Moshu Bhattacharya holding that it
Cannot be done.
beyond, but there are contrary decisions of the Delhi High Court.
Now it is before the
It is
Supreme
before the
Court.
Supreme Court. So
Yes.
if my lord sees the last order, it was adjourned on that ground. Still pending.
Then let it be adjourned again. What can be done?
Petitioner is
But
not there.
petitioner is not here.
Not there. So,
Passover,
my lord.
second call.
Oh, my lord, I'm also party to the arbitration. So my lord, retired honorable judge of the
Very
Calcutta High Court is presiding arbitrator. So
I know about this matter.
my lords.
Yes, next.
Item number 27, WPA 1090.23, along with item number 28, 29, 30, 31, 32.
Yes, sir.
My lord, the petitioner's society is formed by educated unemployed youth.
You are for the petitioner.
I am for the petition. And they were awarded works, 6 works was awarded, work was completed, but till date, way back in 2010, till date the payment is not released. Only one document I want to show. My lord may come to page 33.
Why so many writ petitions?
They are separate work orders.
Separate work orders.
Separate work
You
orders.
are appealing for the Panchayat
Yes,
Samiti.
respondent.
My lord, page 33. Kindly come once to page 33.
30?
3.
Yes.
My lord, this is the note forwarded to the superintending engineer by the executive engineer under whom this work order was there, 21/10/23. May I read, my lord?
I am reading it. Yes, Mr. Chakraborty, this is your client's note, internal note.
But my lords, the point is, my lords, that it had to be verified by lords, and there are various disputes. There is an arbitration clause in the GC.
This is the dispute. Your client says satisfactorily completed. After 12 years, also in very good condition.
Kindly see
This
my
is not right.
opposition, my lords, in an affidavit in opposition, my lord.
My lord, this is there.
Doesn't matter. This is your client's internal note. Whatever you may have written, it will be afterthought. You complete the procedure, either reject the claim, say that no, we will not pay.
My lords, let me take instructions.
My lord, there is no arbitration clause in this.
GCC,
Take instruction, come back day after tomorrow
my lord.
or Friday, whatever you like.
Friday, my lord.
Friday.
Obliged, my lord.
Learned advocate for the, this is a bunch of matters, huh? The order has been passed together, combined order. Says that the petitioner society has been formed by unemployed persons. Stop. The work that was awarded to the society,
Cooperative society.
the work orders that were issued in favor of the cooperative society have been completed to the satisfaction of the respondent authorities. Stop. However, comma, bills for such works are long pending.
Withheld amount.
But withheld amount. However,
Bill was paid, but 10% towards security deposit, 10% towards test check.
the withheld amount on account of security deposit and
10% towards test check by the executive engineer.
and test check by the executive engineer, comma, is not being disbursed. Stop. Learned advocate draws to my notice an internal note generated
By the executive engineer to the superintending engineer.
generated by the executive engineer for the attention of the superintending engineer.
Yes, superintendent engineer PRI.
Paragraph, learned advocate for the Respondents seeks a little time to obtain instructions in the matter. Paragraph. Let this matter be listed again on give Friday's date. Stop. Paragraph. Prima facie, it appears that the respondent authorities are satisfied with the work done by the petitioner society. Stop. Therefore, comma, there does not appear to be any legitimate reason for withholding the monies that are payable by the respondent authorities to the petitioner society.
Item number 33, WPA 100 on of 23, along with item number 34, 35, 36, 37.
My lord, I am appearing on behalf of petitioner, my lord.
My lord, I am appearing on behalf of the respondent. I am seeking extension of time to file opposition.
Waiting for you, my lord.
How long you want?
2 weeks.
It was once extended.
My lord.
Sir,
My lord.
it was extended once.
Yes, my lord.
Extended
The
only.
last extension
Last
may
time
be
also,
given.
big time.
Once or
One final
twice? How
chance
many
may be
times?
given.
How many times extended?
One final chance may be given, my lord. I will file it in within 2 days, 2 weeks.
I'll give a name. Then people.
It appears that on a number of occasions, time to file affidavit in opposition was extended. Stop. Again, prayer is made on behalf of the respondents for extension of time to file affidavit. Paragraph as a last chance, comma, I grant 2 weeks to the respondents to file affidavit in opposition. Stop. This extension is peremptory. Stop. The petitioner will be at liberty to file the petitioners, it's a combined order again.
Combined.
Petitioners will be at liberty to file affidavit in reply within a week thereafter.
Yet.
Paragraph lists the matter under the heading hearing after 3 weeks before the then available circuit bench.
Highly obliged, my lord.
List the matters, bunch of matters, list the matters.
Item number 38, WPA 107 of 2020.
Well, this matter can be taken up, my lord, finally. Final hearing.
Yes. Affidavits are complete.
Yes, labor court challenges order of labor court.
You want to do it now?
My lord, it is his application, man.
Stated, my lords may have it tomorrow, my lords.
Tomorrow.
Item number 40.
I'm praying for a days accommodation.
Praying for?
1 day accommodation. Tomorrow.
I'm appearing for official response.
I'm for the private rescue.
Item number 42, WPA 950 of.
Day after tomorrow, my lord.
Reply has to be filed in the next second.
I am for the petitioner in 40.
Reply.
43.
No, 43 is not connected with.
No, it is
42, my lord.
connected.
It
We
is
heard
connected.
together.
It is not connected, my lord. I will argue that my matter.
No, it is connected.
Hey,
Certainly.
we'll see, we'll see.
Day after tomorrow.
हो जाएगा.
Day after tomorrow.
Reply file करना है ना?
हो जाएगा, हो जाएगा.
Reply.
Let it-
Day after tomorrow,
Day
my
after
lord.
tomorrow.
Item number 44, WPX 36 of 2018.
44. My lord, I am appearing for the respondent.
My lord, just not today in this matter, my lord.
Item number 45, WPA 267.
I am appearing for the respondent.
I am appearing for the petitioner, my lords. My lords, this case, my lords, the compass is, it's a very narrow compass. My lords, this concerns, my lord, certain retiral benefits, my lords. The petitioner is, my lords, the Andaman and Nicobar Islands Industrial Development Corporation, my lords. My lords, this is not a government department in the sense that, my lords, it is a PSU, my lords. It's a company, my lord. Now, my lord, there are.
It's a PSU, but controlled by the government.
Yes, but my lord, all the benefits which are applicable to government servants are not applicable here, my lords, because they have a board of directors who independently take decisions, my lords, and the decisions so far as retiral benefits to central government servants is not per se applicable to them. So, my lords, the petitioner, my lord, they were the petitioners before the labor court, my lords, they were all, my lords, contractual workers. Now, kindly see, my lord, the only issue, my lords, which we raised before the labor court, kindly have a written objections, which are at page 42. This is what the case is all about, my lords. Kindly have page 42. Paragraph 1. The first party workmen were engaged in the second party corporation and were deployed in various units thereof as DRMs, which is daily rated Mazdoor. My lord will be aware, my lord, daily rated Mazdoors are workers, my lords, who fortunately or unfortunately in the islands in particular, my lords, they have a large number of the requirement of public employment, my lords, is being carried out through these contractual persons who do not even have a agreement. Their contract in effect begins in the morning and comes to an end in the evening. But my lord, they are carrying out various works, including highly specialized works. Now, kindly see, my lord, were deployed in various units thereof as DRMs, casual Mazdoors. The first party workmen were brought under temporary status on scale of pay. So, my lord, that is an improvement. Thereafter, these first party workmen were brought under regular scale of pay time to time. The first party workmen were allowed 1/30th of the minimum pay scale plus DNS allowance in pursuance of the Honorable High Court of Calcutta at Port Blair from the date of initial appointment till their temporary status. So, whereas 1/30 basically means the basic wages for a month plus DNS allowance. 1/30 is 1 day's wage plus DNS allowance. So, that for somebody who is employed over a period of time, that translates into the whole wage for the month plus DNS allowance. The second party corporation has allowed past service benefits like gratuity from the initial date of their engagement as DRM, casual Mazdoor, to the first party workmen. Now, kindly note this, my lord, the second party corporation doesn't have pension benefits. Therefore, denial of pensionary benefits doesn't arise. The second party corporation has allowed other retirement benefits like EPF, leave encashment, gratuity, etc. to the first party workmen as per the government rule. Initially, there was no regular staff in the corporation, and corporation has engaged staff on daily rated basis, contract, deputation, etc. since 1990. The corporation, based on its activities requirement, created the posts and framed recruitment rules for the posts during the year 1999 to 2000. Thereafter, regular appointment was given to contract temporary status employees. Seniority has been given from the date of regular appointment. So, my lords, we now see the consideration of the labor court's consideration and on the issue on which, my lord, we have joined pause. My lord, the award, impugned award of the labor court, my lord, begins at page 166.
Yes.
My lord may have the award at page 166.
166,
annexure P3. This incident in ID case arose out of the notification, whereas a conciliation proceeding initiated by the conciliation officer, Assistant Labour Commissioner over the past service benefit raised by Shri GP Money and 32 others employees of Enitco Limited, Port Blair, as the employer denied the extension of past service benefits has failed. Hence, the reference has been sought in exercise of powers conferred under subsection 1 of section 10 read with subsection 5 of section 12 and section 2 capitally of section 10 of the Industrial Disputes Act, read with notification such and such. After consideration of the report, orders to refer the said dispute in the following schedule of reference. Now, my lord will see the terms of reference. Whether the action of the management of Enitco Limited, Port Blair, in regard to denial of extension of past service benefits like seniority, gratuity, and pensionary benefit from the date of initial appointment as DRM casual mazdoor prior to the regular appointment to Shri GP Money and 32 others is legal and justified. If not, what relief the concerned workmen are entitled to. In view of this reference, present first party member has now come up before this labour court with their statement of demands. It remains stated that the present first party members prior to the reference had earlier sought 1/30th of pay of the minimum of relevant pay scale plus DNS allowance for work of 8 hours a day as per office memorandum dated 7 June 1988 issued by the Government of India, Ministry of Personnel and Public Grievance and Pension Department and Training. On failure of a conciliation, a reference was sought before this tribunal, which was considered, and an award was passed on 19 September 2008, directing the second party to pay 1/30th of pay of the minimum of relevant pay scale plus DNS allowance for work of 8 hours per day. On one writ application was filed by the second party before the Honorable Court Circuit Bench at Port Blair against the said award, and his lordship affirmed the award of the tribunal. The order of this Honorable Single Bench was again challenged before Division Bench by filing mandamus appeal at the Circuit Bench, and their lordships affirmed the order of Labour Court, which was complied by the second party. Now, on 8 October 2012, all the first party workmen filed their individual representation for equal pay for equal work and also to regularize the service of the first party from the date of their initial appointment. The reason was that the court already held that first party workmen were discharging similar nature of work as that of regular employees. Therefore, first party workmen who are similarly placed at par with regular employees, they were entitled for extension of past service benefit like seniority, gratuity, and pension benefit from the date of the initial appointment as DRM casual mazdoor prior to the regular appointment as such, and they filed a conciliation proceeding, and in the said proceeding, the second party, vide their letter dated 30th April 2013, denied to first party the said benefit, and as divergent views existed, conciliation officer submitted a failure report on 23rd April 2015, and thereafter appropriate government with a notification dated 3rd June 2015 referred the matter to their court. Now, the contention of the first party is that the first party workmen rendered their services daily rated mazdoor casual workers discharging duties at par with the regular employee in the respective posts, and they were not considered at the time of regularization of service of the first party workmen. This caused loss to the first party workmen. The first party workmen now have twofold prayers before this honorable court. A, an award seeking pay to the first party benefits like seniority, gratuity, pension benefit, and leave from the date of initial appointment as daily rated mazdoor, casual mazdoor, were the second party, and B, be provided with equal pay for equal work to them at par with the regular employee when the first party workmen were working as daily wages contract employee under the second party. The second party submitted the written version where it is admitted that they have allowed past service benefit like gratuity from the initial date of the engagement. The pension benefit was denied as because the second party does not have pension benefits or retirement benefit like EPF, leave encashment, etc. to the first party. It was also agitated that there was no regular staff in corporation, so staff on daily rated basis, contract or deputation were engaged since 1990. Thereafter, the second party framed recruitment rules for the post and framed rules for the post during the year 1999 to 2000. Thereafter, regular appointment was given to contract temporary status employee, including seniority from the date of regular appointment. The second party has also denied categorically that increment was not given to the first party while they were discharging duties as casual workers. It was also stated in written objection that activities of the second party in these days were not perennial in nature, and hence there were no regular staff, and for that reason, DRM contract or employees on deputation were engaged. It is only after 1999 to 2000 when the recruitment rules were framed and regular appointment was given to temporary status contract employees. Seniority was also given to them from the date of regular employment. Evidences were led by both the parties before this tribunal. GP Money submitted his affidavit in chief along with documents which were marked as Exhibit 1 with objection and Exhibit 2. He was cross-examined fully by second party. Arumugam submitted his affidavit in chief, who was also cross-examined in full by second party. One Shri Basuki Nath, general manager, submitted his affidavit in chief and was fully cross-examined. Arguments were heard from both sides at length. The first party, besides submitting everything which was stated within their statement of demand, submitted cordially these points. First, the second party were given their dues with their office memorandum dated 7 June 1998. They now claim equal pay for equal work. It is because actually when the first party members were performing their duties as casual worker temporary status, they were discharging their duties of a regular worker. Hence, they were demanding equal wages for equal work for that period. They demand minimum of regular employees. The following decisions were cited. Per contra, second party submitted likewise besides the contention, written contention. It is correct that the first party were allowed the benefit of office memorandum dated 7 June 1988 by giving them 1/30th of pay, a minimum of relevant pay scale plus dearness allowance. But now this demand for equal pay for equal work to the first party when they discharge their work as DRM temporary status only on the basis that they were performing jobs of regular workers. If this tribunal now allows the pleas of the first party, then it will be illegal. Actually, the second party are seeking regularization in the matter.
Second party seeking regularization.
That should be first party.
First party.
Are seeking regularization in this matter. The plea has been raised after 15 years and it is badly hit by delay and latches, and practically they are now estoppeled from seeking the said demand. Moreover, first party were unable to prove their case that they were discharging the work as regular employees. The instant case is liable to be dismissed. In support of the contention, following citations relied upon by the second party. Now let us see precedent-wise which case is applicable best to the instant industrial dispute and trite question or doctrine of equal pay for equal work, whether applicable or not. The first party cited the case reported in such and such. Basically, through this judgment conveyed that central, this is 1986, my lords will note, before the 1988 office memorandum, that central state government public sector undertakings to function their model enlightened employer and should not argue against principle of equal pay for equal work as abstract doctrine. This court takes opportunity to discuss this doctrine because this particular doctrine of equal pay for equal work from time to time by the Honorable Apex Court put for divergent views. This present citation, the famous Nehru Yuvak Kendra case, was discussed in Nehru Yuvak Kendra case. The bench of his lordship issued following directions that where the persons considerately performing the same duties as class 4 employees, same conditions of service are being received by class 4 employees, salary and allowance will be given like that of class 4 employees. About regularization, the view of the lordships are very clear that unless posts are sanctioned posts, their employment cannot be regularized. But in the same time, their lordships took the view that central government must take steps to create sanctioned posts, and therefore their lordships took into consideration the Nehru Yuvak Kendra case to pay the petitioners and all daily rated employees the same salary and allowances as are paid to regular and permanent employees with effect from the date when they were respectively employed. Thereafter, taking into consideration the next citation, I was very clear that it said that equal pay for equal work being directive principle, non-implementation would amount to discretion. This case was the case of staff artists of Doordarshan performing various kinds of jobs as per their skills and specialization in their respective fields, and same like the staff of All India Radio. Their nature of work was like that of staff of film division, which is also a government machinery, and their staff are also government servant, which was considered by the Honorable Apex Court reported in such and such. Their lordships held unanimously that staff of Doordarshan are also like the staff of film division who are already declared as government servant and both come under the same ministry. They perform identical and same nature of duty, and it would be unreasonable and unjust to discriminate.
Mr. Shokru, they don't read the entire order. Come to, because the case law has been discussed.
Yes, madam.
Come to internal page 12.
Yes, madam. So all this case law has been copiously discussed. And then, my lord, kindly see page 176, internal page 12. In the instant case, following all the principle laid down by Apex Court with respect to the doctrine of equal pay for equal work goes in favor of the first party. It can be said that the first party member demanding equal pay for equal work before Anitco management was legal and justified. The reason is simple. It is Anitco who extracted their work when they were working as casual employees and later on they were regularized. Hence, it is conceivable that those posts were actually for the regular workers. Now, if those employees demand equal pay for equal work, And that also in minimum, they are not demanding anything big. Therefore, it can be said that first party are entitled to get all benefits of regular employees, save and accept all those benefits already given and also equal pay for equal work. So, my lord, there is no consideration at all, my lord, of the question whether they were performing work of a regular employee. Those issues have been raised by the employer, my lord. It is simply, my lord, the judgments have been discussed, and then eventually a conclusion has been reached that they should get the same benefit.
Evidence is on record.
There is no discussion, my lord. The evidence has not been appreciated at all.
I can look into it.
My lord, labor court, my lord, ideally, my lord, there is court of first court, my lord.
You want to remand?
Because according to me, my lord, the issues there is no application.
Evidence should have been discussed, Mr. Vignu. Because that is a factual issue.
My lord.
Evidence should have been discussed.
And my lord, what are the benefits that we actually give to the
Without
regular
protracting the matter, I can remand with a time frame to take a
But my lord, kindly consider this, my lord. My lord,
you are now regularized.
I have been regularized, and my lord,
So it's a question of only your financial claim for that period.
my lord, financial claim, my lord, when they have accepted by paying 1/30th, they have accepted that the nature of duty which I have discharged was of a regular employee. So once they have accepted, because we approached the court, ultimately matter went up to the Supreme Court, and thereafter only they made the payment so far as that party is concerned. Now, my lord, once they have accepted that I discharge the duties of a regular employee under the dint of an order of the court, thereafter whether they can deprive me the other benefit which I am otherwise entitled under the law. So, my lord, this is a pure question of law. Now, my lord, already evidence led, my lord, the language ought not be, my lord, much convincing, but the discussion is there. The court has said equal pay, equal work, and the statement of the witnesses, their cross-examination, everything has been taken note of in the judgment. It is not that it has not been taken out. Now the question, my lord, how far a writ court can interfere with the order of the labor court? When my lord finds that it is a patent illegality, then only my lord can interfere, my lord. There are authorities on this. So, my lord, there is no wrong in the order passed by the labor court, my lord. After full dress trial, the labor court has discussed everything, not in so much words, but it is there. The discussion is there. So, my lord, I pray, my lord, there is, it is not, my lord, my respectful submission, there is no wrong in the order passed by the labor court. My lord, if the matter is posted tomorrow, I will cite at least 3 judgments on this court that unless and until there is a patent illegality, my lord, because it is not an appeal, my lord.
That is also correct.
Yes.
So my submission is, my lord, there is a patent illegality because I do not have pension.
That my lord has to see. No pension is there, my lord. My learned friend cannot say anything which is contrary to record.
It is stated on affidavit, my lord.
You can say.
It is stated on affidavit, my lord, that there is no pensionary benefits because
evidence is there, my lord.
Doesn't have pensionary benefits, my lord. So
evidence is there. Corporation is having, my lord, my learned friend is not aware of it. Corporation is having. My learned friend is not aware.
These aspects have to be decided by
the show me.
Pension is there, my lord. My learned friend can ascertain from. They may say anything, my lord, now. And my lord, evidence is there before the trial court. I will place the evidence.
That's exactly what the learned
evidence is
required to go into and.
My lord, there is no patent illegality. My lord has to see whether there was any, because opportunity was given. They failed before the labor court to demonstrate that there is no pension.
Where is the finding to this?
In the writ court, whether they can say that.
There is no finding before the learned labor court. The learned labor court has only mentioned several judgments and said equal pay for equal work should be granted without at all going into the question what are the benefits that are available to regular employees, whether they have performed work of regular nature. My lord, then there is no purpose of having 1/30th, my lord, of basic pay plus DNS allowance. If, my lord, the intention was that casual workers are to be paid the same salary as regular employees. My lord, this will be completely, my lord, it will be completely contrary, my lord, to law in that sense.
Yes.
A person who enters into contractual employment, my lords, Uma Devi and subsequent judgments, is aware of the incidents of service, my lords. There is a reason 1/30th of benefit is a by way of executive, by way of a judgment, and subsequently by executive policy, certain benefits have been conferred to casual workers performing work of regular nature. But that doesn't mean that they are equated to regular employees, my lords. Regular employees are appointed through a particular process, my lord, through a public advertisement. My lords, they know the incidents of service.
Chakravarti, question is that these very employees you have absorbed by creating posts. Now, the kind of work that they are now doing,
My lord.
it was the same kind of work that they were doing
We
then.
have stated before the labor code that it is only later on that that the work was regular in nature. This is our.
No, my lord, this is not the.
I
stand,
read from the impugned order also, my
This
lord.
is not the
This is
stand.
exactly the stand that only in 1990, earlier we were only having casual nature of work.
No, my lord, that's why 1/30th was paid. Office memorandum says, my lord, if a person discharge the duties of regular employee, then only he is entitled. After a full trial before the trial court, this order is passed.
If this point was to be accepted, then what is the point?
Today, my management cannot argue that.
What is the point of having the 1/30th circular at all if persons who are daily rated Mazdoors are to get all the incidents of service of a regular?
What relief the labor code has given, my lord?
Regular-
Seniority, gratuity and pensionary benefit.
No, so therefore.
Which is what labor code has given.
But this, my lord, will require a full dress.
Pensionary benefit, how if they say there is no
Pensionary
pensionary
benefits there, my lord. I will show from the record, my lord. I will place
Then affidavit says no.
My lord, before the trial court, they have failed to demonstrate the same before the trial court. There is no pensionary benefit. Reduce the evidence.
That's the problem. There is no such discussion by the trial court.
My lord, let me go through the lower court record. Let it be posted.
I will only look at the order.
My lord.
There is no discussion. That is why I was suggesting a time-bound remand.
My lord, but my lord, kindly consider, my lord, by this time, several of the employees were already retired from service. Their pensionary benefit, everything has been stalled.
Yes. So I'll give a time period of 4 weeks or 6 weeks.
It is my respectful submission. The order is not bad, my lord.
Of course, that will be your submission. But I am not happy with.
My lord, let it be posted tomorrow. I will place from the record itself. And I will cite the judgments, my lord, on this because there is no patent illegality, my lord.
Judgments is all right. You see, no judgment can cover all.
Factual aspect it cannot be, my lord.
Yes.
But during the discussion, my lord, it is not that judgments were never discussed. It was stated. In the judgment itself, it is there. The evidence and all has been stated that witnesses were examined. Everything is there, my lord.
To what effect?
Properly read, my lord.
Anyway, come back to one. Heard learned counsel for the parties, stop, to enable learned advocates to cite decisions, comma, let this matter stand adjourned and be listed again on give tomorrow's date.
Item number 46. WPA 119 of 2020.
Let the matter on next week.
Next week.
I'm appearing for respondent.
Item number 47. WPA 46 of 2021.
Your worship, Monday, let it be on Monday, your worship. Possibly I will withdraw the case, so let it be on Monday.
Item number 48. WPA 152 of 2021.
Crossover. Yes.
Lord, can application has been filed for substitution of the writ petitioner because writ petitioner expired, my lord.
48.
It is
48. Substitution be allowed, Mr. Chakravarti.
My lord, here, my lord, the question is, my lord, whether this, the cause of action survives, my lord.
Doesn't survive. What was the nature of cause of action?
This is in respect of a license. So, my lord, under the, my lord, my learned friend has to satisfy, my lord, that license, the cause of action, where the license will survive after the death of the first licensee under the 1966 regulations. That is why this application has been pending. She can
my lord, my license.
The regulations provide for
The earlier writ petitioner. He had got the license on the basis.
A license.
It's not there.
Heritable commodity.
It is heritable, my lord.
Under the rules.
Under the rules. It is heritable, my lord.
Show me, show me. Show me.
Let them show, my lord, it is not heritable.
How can this show something which is negative?
My lord,
Show us. Show
my lord,
me.
let me, my lord.
Show me that it is heritable. No problem then.
It is heritable, my lord. 148.
Know the rule.
The cultivation of, no. It's a license provided that the cultivator level license is writing has granted.
One 148 applies to tenants. It does not apply to licensing. That is the point. Various classifications my lords have provided.
Correct. In contradistinction, 147 does not say so.
My lord, but my lord, the writ petitioner, he himself got the license when his father was died. His father was not there. On the basis of that, only that license was granted to this writ petitioner when the father was not there.
Doesn't matter, madam. You
The
show me
same
the.
was applicable here also, my lord.
No, cannot.
Yes, my lord.
Unless you show me.
I will satisfy.
You will be
Tomorrow,
satisfied.
tomorrow I will satisfy. my lord. I will satisfy tomorrow, my lord.
Sure, not today.
Every land is heritable, my lord.
147 talks of license, 140 talks of tenant. 148 makes it clear that it is heritable in case of tenancy. But license, I have my doubts.
Once the license is granted to the any tenant, my lord, it is heritable, my lord.
Show me,
It is
show me,
heritable.
show me. You
I
can't
will
show
show the law, my lord.
Yes.
Tomorrow I will show you.
Item number 49. CRA on of 2022.
IPA for the state election, there was a direction upon the SHO concerned to file a report with regard to the accused person. So he has submitted a report whereby he stated that he is not to be found.
Petitioner is not there, madam.
Accused is not to be found.
Petitioner is not there.
Petitioner myself, state
This is 40?
49.
Oh. Okay.
The report may be taken on record, your lordship.
1 second. Yes.
Yes. Now, what has happened, your lordship, on 11th of January 2024, this honorable court passed an order by which the station house officer was directed to produce the accused person before the learned chief judicial magistrate. So there he was produced, and there was a specific direction of the honorable court that he should remain present and he should meet the SHO concerned every week. But after some times, he's found out absconding. Now, the order of 3rd July 2024 may kindly be seen.
What, he was granted bail or something? It was one of the conditions of bail.
It was there was a bail, and order 3rd July 2024, there is an order of this honorable court that if he is found not present, so necessary orders may be passed to ensure his attendance. 3rd July.
Yes.
Now, appropriate direction may be given upon to the concerned CJM
To secure his presence.
to secure his attendance.
Before
Warrant
the-
will be issued now.
Yes. But then, should I dispose of this application by that direction?
It's an appeal. His attendance.
This is an appeal.
It's a criminal appeal. In view of the order on
Issue.
3rd July,
Come. Oh, appeal against acquittal.
acquit.
On July 3, 2024, a coordinate bench pass the following order, set out the order. Next, on July 10, 2024, the station house officer was directed to file a compliance report in terms of the direction contained in the earlier order dated July 3, 2024. Paragraph. Today, such a report has been filed. Such a report dated July 29, 2024, has been filed. Stop. Let the same be kept with the records. Paragraph. It appears from the said report that several attempts were made to establish contact with the respondent, but his mobile phone was found to be switched off. Stop. Efforts were also made to trace him out in his locality and nearby areas, but he couldn't be found. Stop. The station house officer has made a prayer for issuance of warrant of arrest against the respondent. Paragraph. It appears that the respondent is absconding. Stop. Hence, I will issue who will issue warrant of arrest?
That court of CJM. Where he was
Hence,
granted
the learned court of Chief Judicial Magistrate
at Port Blair.
at Port Blair is directed to issue warrant of arrest against the respondent to secure his attendance before the Chief Judicial,
Before the Chief Judicial.
before the learned magistrate's court,
Before whom he obtained the bail.
before whom he had obtained bail. This matter, what should we do with this
Let-
matter?
Next circuit, your lordship.
Next
because-
circuit. Paragraph, let this matter be posted before the next available circuit bench.
Copy of this order may be sent to learned Chief Judicial Magistrate.
Department shall send a copy of this order to the learned Chief Judicial Magistrate, Port Blair immediately.
No.
Item number 50, CRR 23 of 2022.
IP for the state respondent.
Pass over.
For the petitioner paying for next week.
Next week.
Item number 50 on your 29 of
I am
2022.
appearing in this matter. Mr. Shamal Kumar Mukherjee will appear on virtual mode. I pray on first this matter may be fixed.
1st August.
1st of August.
Item number 52, WPA 173 of 2022.
My lord, my senior appearing for the petitioner, Gopala Vinu Kumar, my senior, fixed for not today. I am praying for not today. 53.
Item number 53, WPA 397 of 2022.
I am praying for not today, my lord.
Item number 54,
Your lordship, I am for the petitioner. Here I have challenged the criminal proceedings so initiated against the petitioner, your lordship, on the basis of a complaint case.
My lord,
Defamation case.
482.
Yes.
482.
Yes.
my
For
lord,
quashing the
fixed
entire.
Monday.
Monday,
Not Monday, your lordship. Let it be not today.
not today.
Let it be not today.
But my senior is appearing in this matter for the.
Yes, many of the matters are fixed tomorrow, so let it.
Let it be on Monday.
Let it be fixed tomorrow, because he will come tomorrow. Let us see.
Let
If
us
he
see.
gets opportunity.
Who is appearing? Oh, Mr. Binnu Kumar.
Next week means it will be difficult, your lordship. It will be a
Let us
burden
see.
upon the court also.
What are the sections?
Your Lordship, this defamation, 490.
Defamation.
was the-
Quashing is difficult,
I
Mr.
know, Your Lordship, he was the employee of the department. He was suspended from service. That suspension order was pasted upon the bus terminal. That is his case. He's issuing a letter to the director. I am the director of transport. He's issuing a letter to the director of transport that somebody has pasted it. So you should inquire upon it. And as there is no procedure of inquiring upon who has pasted and all those things, it is not under his jurisdiction. He doesn't do it. So he filed a complaint case against the director himself that you have defamed him.
Come back to one.
That's what I am submitting.
Let
So
it be on
basically,
Monday.
let it be tomorrow's madam. What is the problem? Let us start tomorrow.
May not be
Because I
taken
can-
up.
I actually-
There will be several cases before this.
That's-
So you need not look worried. Sure, not today.
Item number 55,
Well, item number
CO
50,
14 of 2023.
there are two analogous COs, civil revision was there. One was posted in court number 2 and another one before this court.
No, it should be together.
And the matter fixed there, that is posted in the next circuit. Since the senior counsel from Cuttack, both the parties, they are not.
Then let this be posted in the next set.
Next set.
I am told that a connected civil revisional application has been directed to be listed by a coordinate bench before the next available circuit bench. Stop. Paragraph, let this matter also be posted before the next available
Applied.
circuit bench. Do you have reference of that number of that matter?
Yes, that is,
And-
that was serial number 50 there today.
Take the serial number 50, mention that, huh? I'm
DD
told that a
builders.
connected divisional application being, give that number, serial 50 of that list.
Obliged.
Item number 56, WPA 245 of 2023, along with 57.
Mr. Gopala Binnu Kumar is appearing for the petitioner.
My lord, my senior is appearing for the petitioner. I pray for not today.
Item number 58, WPA 8 of 2023.
I am for the petitioner. There is a direction upon the government respondents
May not be taken
to file
next week.
affidavit. No,
Kindly hear.
Next week,
last order may be seen.
I pray for next week, it may be fixed.
Last order may be seen.
As a
Second
final
order.
affidavit.
I am praying for imposing exemplary cost upon the respondents.
Lord, I have prepared the affidavit as.
How many extensions?
Lordship, from last 1 year extension is going on. Now I am without any forum from last 1 year. And every time they are passing it to the next circuit.
No, no, not next circuit, next week, any day.
Kindly see the previous orders, Lordship, from last 1 year.
Oh, Revenue Secretary's authority.
Yes.
My lord. No, next week, Monday may
Now,
fix,
they
I shall
have
come
been
up.
directed to show the notification by which the power was given. For that, they have taken 1 year, Your Honor, Lordship.
My lord, affidavit direction was given, we have.
On
prepared it.
2nd July, my lord, order may be seen. 2nd July order.
2nd July 2023 order.
24.
My lord, I shall bring the affidavit in
No,
opposition next week.
That also there is order.
Before that.
Yes. July 28, 2023 order, Lordship.
Both the petitioner and the respondent are clubbed together to.
July 28 and 2023. That was the first order in which the time was given.
Monday I shall come.
Several extensions of time were granted in favor of the official respondents to file affidavit. Stop. Today again, a prayer is made for further time. Stop. Paragraph from the records and the earlier orders passed, comma, I find that the writ petitioners, you are who? You are who?
That was respondent number 4, private respondent.
Writ petitioners and the private respondent may have sufficient reason to be aggrieved by the conduct of the official respondents, stop. I was minded to impose costs on the official respondents, but taking a lenient view, I refrain from doing so, stop. As a last opportunity, time for the respondents, official respondents, to file affidavit is extended. Make this paragraph as a last opportunity. File it by Monday
My lord.
till
Highly
his
obliged.
Monday's date. Stop.
By giving advance copy, my lord, so that we can find.
Comma with advance copy. With advance copies to learned advocates for the other parties. You want to file replies?
Just 2 days.
Stop. The writ petitioner would be, writ petitioners would be at liberty to file their reply within 2 days thereafter. Paragraph lists the matter next Thursday.
Yes. Obliged.
Highly obliged, my lord.
Don't say next Thursday, give the date, huh?
Item number 59.
I am for the officer.
Matter be taken up on Friday.
Friday.
Item 60.
Lord, I am for the
83 of 2023.
writ petitioner, my lord. 14th June order was not complied,
14 June.
my lord. June का order है. अपील का कॉपी देना, अपील डिस्पोजमेंट. प्राइवेट पार्टी हमको देना था.
Yes, Mr. Chakraborty.
Private respondent.
You are for private
No,
respondent?
I'm for the statement.
Neither it is
Appellate
complied.
authority.
Appellate authority is sitting tight over the matter.
Yes, it's not-
Ma'am is
I'm thinking
appearing.
of the Private respondent. The answer is this only. Your Worship, let it be tomorrow. I missed this one, Your Worship.
You missed it?
Let it be tomorrow.
Not today.
Item number 60 on WPA 887 of 2023.
I pay for the respondent, my lord.
Paying for the petition, I'm paying for next week.
Item number 62, WPA 894 of 2023.
Let this matter be on Monday, Your Worship, because this also, there is a chance of withdrawal of this matter.
Item number 63.
Although, my lord, some of the most interesting matters are being withdrawn. The earlier one was a shipping matter. This also, my lord,
Thing is that.
concerns
the time has gone. So a new thing has come now.
this
So
concerns the
probably-
policy of the government regarding distribution of cane.
Okay.
Item number 63, WPA 917 of 2023.
63?
Yeah, I am appealing for the respondent of the petition.
Item number 64, WPA 978 of 2023.
I am for the respondent.
Next week.
Obliged.
Item number 65, WPA 1011 of 2023.
My lord, I am for the writ petitioner, my lord. My lord, on the last occasion, lordship has been pleased to grant them 2 weeks' time to file the opposition, lordship.
Mm-hmm.
My lord, I am seeking extension of time, my lord. There is a connected case, which I have.
The approving person.
No, my lord. Advocate. My lord, I am seeking extension of time to file affidavit in opposition, my lord.
Last time,
Last, on several occasions, lordship, they have
Several
sought for time, lordship.
what
There are
is
series
this?
of two cases, my lord. One case come up in the other court, and this case. How does it?
Hey, come, let's take it down.
2 days.
Oh, no, file it next week.
Next week. I will.
On several occasions, extensions of time were granted to the official, to the official.
Respondent number 8 is duly represented.
Private
That
respondent.
is official respondent or private?
Private.
To the official respondents to file affidavit in opposition, stop. Today again, further time is paid for. Paragraph. Peremptorily, I extend the time for the official respondents to file affidavit in opposition till Monday. Give them date.
My lord, Tuesday, my lord.
No, 2, 3, 5, 4 months. What is this?
Oblige, my lord.
Monday, huh? So reply there too, comma, if any, we file writ petitioner, yes. You want to,
Lordship.
how much, 1 week?
1 week time, lordship, 1 week.
Within a week thereafter, mention the dates, huh? Paragraph lists the matter before the next available circuit bench.
Highly obliged, my lord.
Grateful, your lord. Deeply obliged.
Item number 67. WPA 1069 of 2023.
66 has already been fixed for 66.
Fix it, mention here. 7 day after tomorrow.
67.
Item number 68. CRSV on of 2024.
Item number 68 is the advocate is appearing for the petitioner. Mediation is fixed tomorrow. To let the matter moving on day after tomorrow.
Item number 69. WPS 6 of 2024.
Where did you reply?
I see my.
Affidavit in reply filed on behalf of the writ petitioner. Be kept with the records. When do you want it? Paragraph lists the matter once again on day after tomorrow's date for final hearing.
Item number 70. WPS 68 of 2024.
This matter, my lord, was argued actually in the last circuit also. Here the question is, my lords, L. Chandramukar and Avdesh Singh, the full bench of our, my lord, clearly applicable, my lord. They have to explain, justify how it is maintainable before this honorable exercising Article 226 jurisdiction.
Yes.
I'm also appearing official
Lordship,
respondent.
I am for the petitioner, lordship.
Yes.
Lordship, on the 2-3 occasions, lordship, they have taken this point, lordship, on the point of maintainability. And to that effect, lordship, affidavits has already been filed by both the parties, lordship. It has also been exchanged. Now, lordship, only the requirement is, lordship, the hearing on the merits of the writ application, whether, lordship, the petitioner is entitled to any relief or not, lordship. Lordship, it will take some time, lordship, to conclude, lordship. If your lordship be pleased enough to fix the matter tomorrow at any convenient time, lordship.
No particular time can be fixed, sir. Sorry. We can keep it tomorrow, no problem, but no.
Lordship, it will be grateful, lordship, if your lordship be pleased to fix it tomorrow, lordship.
I shall. In the merits, you have to show us how this is maintainable, the writ petition.
Lordship, there is a maintainability, lordship, because it's a matter of fundamental right and natural justice, lordship. I
Oh.
shall try my best to, Lordship, to
Come back.
satisfy your Lordship.
Very well. Come back.
I'm so grateful, Lordship. Most obliged.
Item number 71, WPA 18 of 2024.
Item 71. The time to file reply needs to be extended. As Lordship, there is a bereavement in the family members of the writ petitioner. I require justice 3
You're,
weeks.
you're enjoying any interim order?
Yes.
Who is the other side? Bereavement, he says.
Yes, that's the ground, so I can't understand.
How long?
3 weeks.
Learned advocate for the writ petitioner says that because of a bereavement in the family of the writ petitioner, comma, affidavit in reply could not be prepared. Stop. 3 weeks time. Weeks, apostrophe, yes, apostrophe, yeah, is sought for. Paragraph. Learned advocate for the respondents, comma, in her usual fairness, comma, does not oppose the prayer. Paragraph. Let affidavit in reply be filed within 3 weeks from date. Mention the date. Stop. List the matter after 3 weeks before the then available circuit bench. Wait. Oh, it's a department? Okay. Yes. Delete it. Delete it. Delete that sentence.
Item number 72, WPA 83 of 2024.
I'm appearing for
One
One.
out of 2. The other matter was substantially held by court number 2 today.
Then let this go there.
Direction in the courts.
Let this go there. Yes. A 72. Do you have the number of that case? I am told that a connected matter being WPA such and such is in the process of being heard by a coordinate bench. Stop. Let this matter stand released from my list and be placed before that bench.
WPA number 82 of 24. Of court number 2.
I'm appearing for respond number 1, my lord, 2 and 3.
2 and 3.
Highly obliged, my lord.
Item number 73, WPA 91 of 2024.
Hearings are complete.
I was given time to file affidavit in reply. That is final stage. Next week I will file. Monday or tomorrow.
Monday will file. On the prayer made on behalf of the writ petitioner, comma, time to file affidavit in reply is extended till give Monday's date, comma, stop. Let the matter be listed for final hearing Tuesday's date on.
Item number 74, WPA 167 of 2024.
Do you have water logging here? No. If it rains heavily, no water logging.
That's a problem also, my lord. The water doesn't stop. Otherwise, my lords, there would never be a water shortage in the islands. But unfortunately, the water is.
Yes, item 70.
Item number 74, WPA 167 of 2024.
Pass over.
Item number 75, WPA 184 of 2024.
I am appealing for the petition. My lord, affidavit in reply has been filed today. That will be fixed for tomorrow for hearing.
हमको दिया था.
Not today.
हमको दिया था. ये judgment
Item number 76, WPA 204 of 2024.
Taken up tomorrow, you know.
76.
76.
76.
Not today.
Item number 77, WPA 205 of 2024.
Day after tomorrow.
Item number 78.
Because here my कितना time से?
24.
I'm a petitioner. There was a direction to.
We have, my lord, we have prepared it and sent it to the department, my lord. 1 week extension may be granted. 2 weeks for vetting
Next
purposes.
circuit.
Fine.
On the request made by learned advocate for the respondents, all respondents.
Yes, ma'am.
Comma, time to file affidavit in opposition is extended by 2 weeks from date. Mention the date. Stop. Reply thereto, comma, if any, be filed within a week thereafter. Paragraph lists the matter after 3 weeks before the next available settlement bench. Make a second call. Second call. Passover matter, huh?
Passover matter. Item number 2, CRM SB 5 of 2019 with item number 3, CRSB 10 of 2019.
Lordship, this matter, my lord, this is a case of 138 of NA Act. That the appellant herein and the private respondent, there is a chance that they may compound the matter, my lord. Since the
You are for the
I am for the appellant here.
appellant.
So there is a chance that they may compromise. Only the thing is that the private respondent is settled down in Kerala. So let this matter may be taken up in the next circuit, my lord, so that they may have outside the court settlement.
Learned advocate for the appellant says that this matter pertains to section 138 of Negotiable Instruments Act. Stop. The accused and the de facto complainant may come to a compromise. Stop. Paragraph on the request made by learned advocate, comma, let this matter be placed before the next available circuit bench. Next.
Oblige.
Item number 5, WPA 324 of 2024.
Manoj কেউ ছিল কি ফার্স্ট কলে? ছিল না তো? Stephen, in the first call, nobody appeared for the petitioner. Stop. In the second call, also nobody appears. Stop. No accommodation is sought for. Paragraph WPA such and such is dismissed for default. Stop. Interim order, if any, comma, stands vacated.
Item number 13, CRR 12 of 2024.
This matter, Mohammed Kabir are waiting for the petitioner and waiting for next week.
Next week.
Item number 15, CRR 24 of 2024.
But from 15 to 18, they are connected, madam. I'm waiting for next week.
Next week.
Item number 23, CPN 47 of 2023.
Contempt, my lord, petitioner is not here.
Nobody was there in the first call also.
No.
Same order, dismissed. This is the formula which we follow in the principal bench also.
My lord.
Same order, huh? Dismissed for default.
Item number 26, AP on of 2024.
Is that section 11, my lord, but
You are not interested to see this dismissed.
my lord, because my lord, his lordship Jyotirmoy Bhattacharya is the presiding. Miss Nag is also one of the arbitrators. So.
Who is appealing for the petitioner?
Mr.
So, tell me, should I keep it on Friday and in the meantime you contact learned advocate? It has to be either dismissed or decided one way.
Or my lord may say that, my lord, the issue is pending in the Supreme Court. It can get adjourned also.
We can
last
adjourn it.
order record, so my lord will see the last.
So I'll do that. I'll do that.
Fine.
The issue as regards extension of mandate, correct?
Yes,
of the arbitral tribunal is still pending consideration before the Honorable Apex Court. Paragraph. In that view of the matter, comma, shall we say out of list for the timing?
My lord.
Let this matter go out of list for the timing with liberty to mention.
My lord.
Item number 74, WPA 167 of 2024.
So coverage is appearing, his junior has left, let it be on Friday.
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 Where is he?
Well.